This courtroom case looks simple at first, but within seconds, everything starts falling apart. One man, one story, but the judge isn't buying a single word. What starts as a normal hearing quickly turns into a tense back and forth where every answer makes things worse. And just when he thinks he can explain it, the truth starts slipping out. Watch closely, because this moment changes everything.
Good morning, you're Mark Garcia.
Yes, ma'am.
And Mr. Garcia, cause number 25, DCCR 0120. You were previously in court. You entered a plea of guilty to theft of material, aluminum, bronze, copper, or brass, a state jail felony, and that was a cap of 16 months in the state jail prison. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
We have to.
I do, Judge. Are there any additions or corrections? Explanations?
Yes, there is one issue that we would like to address regarding his statement.
Okay.
And Judge, that was in regards to his description of what happened, as far as when he talks about them not stealing the copper. I think that was more of an issue of course, him not admitting that they were caught in the act. And this was something that was after the fact that he was stealing the truck. He understands, how that may have sounded, the way he expressed himself, and he totally takes responsibility for it.
So, Mr. Garcia, you said specifically in quotes, we did not steal anything from there.
We didn't, but we were caught there. We shouldn't have been there in the first place. I accept responsibility for what we were doing.
Well, what were you doing? What are you accepting responsibility for?
We showed up to look at the site. We were supposed to check it out. And that's when the cops showed up. I wasn't even in the, I was there. I was in the truck when the cops pulled up, but I thought we were there on a job. So thought we were supposed to be working, we were supposed to land, but we hadn't yet. But I accept responsibility for what we're there to do. You know what I mean?
I don't know what you mean. That's why I'm asking you, because you're saying you were there in absolutely legit reason, and there was material in the back of your. Here's the thing. Now's the time not to gloss over it. Okay? Either you did it or you didn't do it.
Yes, ma'am, I did. That's why. But
that's not what you're saying. You're saying you went there to do a job, and the cops pulled up, and y'all just got in trouble, and you don't know why.
For 10 minutes. I don't know how else to put it in words. I did what I'm accused me of doing. I don't know how else to word it. She asked me to describe the situation. I did.
You said we did not steal anything from there. So did you or did you not steal?
I did.
Okay. So that's not what you just told me.
I don't know how else to word it. I hadn't gone in yet. We hadn't, but I don't say.
But the stuff was in, you had cut copper, a reciprocating saw, drills, and tools in the immediate area, in addition to multiple bundles of copper in the back of the truck. So how, I don't still understand. Did you steal the copper or not?
Yes, ma'am.
So now let's go to your criminal history and the fact that this isn't your first time to do this. You've got 5 prior felony convictions. You've received the max of 2 years state jail on 2 of them. 1, possession of a controlled substance and fraudulent use or possession of identifying information. You've received a 1-year state jail on theft of material. You've received a 2-year term on possession of a controlled substance. What all that means to me is that the deal that you received going on count 1 only, you could have been looking at 2 to 10 instead of just a state jail. And I don't agree. I think after seeing this, Ms. Malfino, is there something else that you either did or didn't know that would go into the state's position on that offer?
Judge, only that in my review of those priors, there were two to state jails that did not need to be sequential, so I would agree that it could be a third degree. I totally understand the court's confusion with something less than is what the 2 years that he has already received, and if we need to revisit that under a third degree.
There's no facts or issues. Is there any, I mean, I guess any underlying facts or issues with the case that,
Not particularly, Judge. I mean, I know some of the people that run the AT&T, and I know this is a very menacing type of offense that then leads everyone else's bill to increase because we're all paying for what they're doing, but nothing particular because of this offense, Judge.
okay, then I'm not going to accept that, that agreement. It doesn't make any sense to get rewarded for continuing bad behavior if there's not some underlying other issue.
And Judge, just to kind of point out there, mitigating circumstances for us. Mr. Garcia, he was dealing with a drug habit. That even is why he's in custody right now from testing positive when he came into court. He has been struggling with that, but he has done some things or to try to move himself from the surroundings he was in, even while the case was pending.
I appreciate all that, but there doesn't seem any reason for me at all to agree to a 16-month sentence when this is his 6th felony offense, and it's the same type of offense. And the last time he was enhanced, or it was at least a 2-year in prison, in TDC, not state jail. He's looking at 2 to 10 if he went to a jury, and I don't think 16 months is appropriate at all. I don't think that's what a jury in our community would think was appropriate for someone who continues to. No, y'all go talk about it if you want to. I can reset it and you guys can kind of renegotiate and look at it and let me know. But at this point, I'm going to reject that offer.
Okay.
Good morning. Are you Eric Segrist?
Yes, ma'am.
And Mr. Segrist is charged in cause number 25, DCCR 1836, with burglary of a habitation. Mr. Lewis has filed a motion asking that I reduce the bond, which is currently set at $50,000. Mr. Lewis, you may proceed. Mr. Segrist, best you can, raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Thank you. Go ahead, Mr. Lewis.
Mr. Seacrest, will you state your full name for the record?
Eric Martin Segrist Jr.
Okay. At the time that you were arrested, were you employed at that time?
I actually I had a job interview for Walmart the next day and I missed it.
But at that time, you weren't working?
No, sir.
Okay. No, sir. Up until the time that you were arrested, were you able to have any money saved or anything like that that you could use to forge your bond?
No, sir. My sister was planning on helping me out.
Okay. So any help would come from your family?
My family, yes, sir.
Okay. Now, the employment opportunity that you did speak of, is that still available to you?
Yeah, as soon as I go home. She actually asked about me yesterday morning.
Oh.
And I have a neighbor in my neighborhood, and she has like a bunch of overgrown trees, and she was asking my sister if I could come over there and clear out all the stuff, and she was going to pay me to help bond out.
And if you're able to make bond, where would you be living?
At 6161 House Street in Groves, Texas.
Okay. Now, is that the same residence as the complainant in this case?
No. So that's my sister's house.
Okay. So you will be able to handle any type of bond conditions, for example, like no contact with the victim, things of that nature.
Absolutely, and the job is walking distance from my house. Like it'll take me 20 minutes to walk there. My house, and I just bought a brand new bicycle, so I could ride my bike straight to Walmart to go to work.
Okay. Now, as far as the bond amount, it's currently set at $50,000. About how much do you think your family could afford to try to help bond you out?
Well, I'd say because I have another bond that's 10,000, and so probably around that area. So she can get a better deal with the bondsman, like around 10,000.
So you're asking for a bond who says it's 10,000 on this case, but ultimately you would have a bond obligation of approximately $20,000.
Yes, sir.
What's the other bond for?
It's for an assault case, I believe, Judge.
The misdemeanor
It's a
assault.
misdemeanor assault case.
Any questions?
No questions, Mr. Judge.
Any other witnesses?
Oh, no, Judge.
All right, Mr. Smith, what is the state's position?
Judge, this was a case where he broke into this house, sliced his arm very badly on the window, trying to break through the window, assaulted the victim in the case, stole her phone, and ran away after the police had been called. They were able to find him because they used to track my iPhone. It's family violence. They were living together at the times. We have had contact with her. She came in and talked to me last week, or before last, on this. So we would be opposed to a bond eviction.
And just for the record, I'm taking judicial notice of the court's file. It does include the probable cause affidavit, and so I have reviewed that as well. Anything else, Mr. Lewis?
Well, Judge, this is the one that we, of course, reset from recently when the state was looking to hear from the complainant in this matter. And I think, like Mr. Smith said, they did have a chance to talk to her. And even from my understanding from that conversation of what we're dealing with is a situation where it's still kind of shaky as far as factually of what went on between him and her that evening. It is something that he definitely wants to pursue. I'm not just going to say a trial, but pursue this matter further as far as trying to get it resolved. He does have plans to hire his own attorney, who's Mr. Parker. He's going now, but that's initially who the family's going to try to help hire for him. So they're looking to bond him out and hire his own attorney as they proceed with this matter. We're just asking for him to have that opportunity. That way he can get back to work and help pay for that on his own and not be situated with any burden obligation on his family moving forward.
Okay, at this time, taking into consideration the factors in Art 17.15, I am going to find that it is not in the best interest to grant the motion to reduce the bond. I'm going to deny that. The underlying facts, the testimony today. And so what we'll do is get it set as quickly as possible. If the family hires Mr. Parker, great. If not, then Mr. Lewis obviously will remain as your attorney and move forward with going through discovery, and we'll get it set for an announcement and move forward as however you guys plan to at that time. Okay, go back with the bailiff. Good morning. Are you Kenneth Bartol?
Yes, ma'am.
And Mr. Parker, will your client waive the formal reading of the indictment in each case?
Your Honor.
I am going to first also, I think we've probably done it, but just to make it clear, I'll take judicial notice of the court's file in each of the cases. Mr. Barthol was evaluated by Dr. Capon for competency to stand trial, and we received an evaluation and report back on November 3rd of 2025. The finding in that is that Mr. Barthol was competent to stand trial. Is there any other evidence with regard to competency today?
No, Your Honor. No, Your Honor.
All right, then based on that, I will find that Mr. Barthol is competent to stand trial and proceed. So, Mr. Barthol, in cause number 25, DCCR 1207, you're charged with a third-degree felony offense of obstruction or retaliation from July 19th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Mm-hmm.
And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
And then in cause number 25, DCCR, that's a state jail. Are we going on count one only in the state jail case?
Oh, so is that
1752?
Yes, Your Honor.
Give me just a minute. In 25 DCCR 1752, the state has elected to proceed on count one only. It alleges you committed the state jail felony offense of possession of a controlled substance from January 11th of 2025. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you actually did what they charged you with?
Yes, ma'am.
And then lastly, we have cause number 25 DCCR 0878. And in that case, you're charged with a third-degree felony offense of obstruction or retaliation from May 24th of 2025. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you did what they charged you with?
Yes, ma'am.
In all three cases, I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreements that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1 in each case.
Objection.
It's admitted. Is there any, again, there's no other evidence about competency. All right, Mr. Barthol, I'm going to find in all three of your cases that you entered your pleas of guilty freely and voluntarily. Find, again, you're mentally competent. You understand the nature and the consequences of those pleas. In cause number 25, DCCR 1752, find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of possession of a controlled substance. Sentence you in accordance with your agreement to a term of 12 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 25, DCCR 1207, also find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of obstruction or retaliation. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then finally, in cause number 25, DCCR 0878, also find that you entered your plea freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of obstruction or retaliation. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to go back real quick because I think I failed to mention, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
Okay. These cases will run concurrently, which means together at the same time. I will sign dismissals as part of this agreement in cause numbers 25 DCCR 1206 and 25 DCCR 1208. I'm handing you in each of your cases the trial court certifications. That shows that these were agreements that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, good luck to you, sir. You can go back with the bailiff. Good morning. Are you Tyree Hartley?
Yes, ma'am.
And this is 25 DCCR 0842. Mr. Hartley is charged with aggravated robbery. And what is the announcement?
Your Honor, this case, I think it's best that we move it to the trial docket. There's still some discovery that I've requested from the state that I don't have yet. I know they're working on that. We have discussed a resolution. We're not close, and I don't think the additional discovery is going to impact Mr. Hartley's decision to pursue a trial at this point based on what he's told
What,
me.
what are
But
we
Judge,
waiting
per
on?
the standard process of this court, I would respectfully ask for a final announcement setting to allow for the compilation of that discovery. There was some stuff that Mr. Wilkerson specifically requested that Ms. Mayfield was able to get with VPD and find. We'll get that to him. There's also things this case extended out of this county, so I have reached out to detectives on task force outside of the county to get stuff from other agencies, which takes a little bit longer than just going across the street to VPD to get it, and be able to get him all of that. I agree with him that we're not anywhere close. He wants a non-aggravated, low pen time offer, and I'm upwards of 20 plus years, especially with his jail reports that keep piling up daily. So I would ask just for a short standard reset to allow me to get all that to him and then do a formal rejection of anything.
So, Judge, I'm sorry, I didn't mean that. This was a case that I was appointed on after a formal rejection was done.
Correct.
So,
So the rejection was just in December, and you had some time to go through it, obviously found some things you need. I'm not inclined to put it on the trial docket without the discovery complete. And so I will do one last reset. This will be the final reset for an announcement. Once Ms. Malfino gets you all the information that you've requested, you can go over that with Mr. Hartley. If nothing changes, then at that time, we will put it on the next available trial docket. As everybody knows, we don't have any kind of backlog on trials. We can get it tried very quickly. So we'll do this last one. You can get everything, and then we'll go from there.
yes, Your Honor.
Mr. Hartley, go back with the bailiff.
Thank you, Your Honor.
Thank you.
Excuse?
Yes, sir.
Thank you.
Good morning, sir. You Robert Trahan? And Mr. Trahan, and clause number 25 DCCR 1094. You're charged with the state jail felony offense of unauthorized use of a vehicle from June 3rd of 2025. The indictment alleges that you were previously convicted of accident involving injury or death, a special degree felony, October 16th of 2017. And after that was final, you were convicted of evading arrest or detention with the use of a vehicle, October 17th of 2022, and also possession of a controlled substance, October 17th of 2022. And so that special degree is considered, have y'all done any research on how that's considered as far as enhancement purposes?
I believe it's considered a third for enhancement purposes. Third, I've got him at 2 to 20. Because
No, just right. If that's considered a third or more,
It's not
then it would be
considered.
2 to 20. I just need to know of the special degree, you think it's considered a third?
I believe so.
Which
Just
would
because
make-
the underlying sentence was 3 years, I believe, before one of the two. I'm confused.
So in the
If it's
indictment,
third degree,
one of the prior felonies that are listed as enhancement is a special degree felony.
policy.
And so it's on one date in 2017. The other two are on the same date. And so in order for it to enhance, I need to make sure that it's considered a third or more and not a state jail
Now I understand.
for punishment purposes. And so I want to make sure we are all on the same page. What is the range of punishment for that?
Judge.
Degree. I haven't had one like this in a while, so
It's they amended that statute to be different now than what it was back then, and that's why it was a special degree in the first place.
gotta know what it was.
It made the minimum.
Actually, Judge, you know what? I have my criminal history here. Let's see what it.
Y'all do this. Let me hold it for
Yeah.
a minute and just double check what that range of punishment was in 2017.
Okay.
Because that would be the law that would be followed. And if y'all need, I have old books. So let's do that first, and then we'll figure it out. I'll just hold the paperwork.
Good morning.
Oh, I can't hear you. Uh-oh.
Let's see.
Hold on. Let me see if that's us or not.
And I can't see anybody. Let's see. But I can hear you. There, I see everybody now.
Right. Say something. Can you,
Yes, can you hear me now?
hold on a second. Let me get my
All right.
clerk in here to help us. For some reason, I can't hear Mr. Udishin. I don't know where the volume is. Thanks. Thank you. It should be. There's no sound coming from Mr. Udishin.
Does he have his own?
Yeah, he's not muted.
Not muted.
Yeah, he's not muted. So I don't know where.
But does he have that? That would, I think, show if you muted your.
No, it would show here if he's muted. Yeah, he's not muted. See, I can mute him if I want to myself, so that wouldn't be there. Hold on. Is it the TV or the Elmo?
The Elmo's on, or else it wouldn't be on the TV.
And I know the TV was turned up yesterday. We have the sound. Yeah. We might do this, Mr. Udishin. I might end the meeting, start all over, and see if we can get you to rejoin, okay? Should be as no 15, 16.
Yes, ma'am.
All right, sir, are you Joseph Freeman?
Yes, ma'am.
And in cause number 24, DCCR 0348, Mr. Freeman is charged with murder. And in cause number 21, 38728, charged with deadly conduct, discharging a firearm. And what is the announcement?
Judge, Mr. Freeman would like a trial. I visited with him last week. He says he wants to go to trial on the murder case. Is that correct, Mr. Freeman?
Yes. Yes, ma'am. Your
And so it looks like, has there been any offer?
Yes, Judge, the state offered to run a 60-year sentence concurrent with the 60 years he recently received from the court in the MTRP.
It wasn't an MTRP, it was two unagreed pleas.
Unagreed. You're right.
The ag robberies.
It was unagreed.
Can you do this real quick just so that I have a paper trail in my file to show why we get it there? If you will do a plea bargain
I
rejection.
think there's one in there already. He rejected 40.
Well, let's put what the new offer is now that the underlying case has been affirmed. And so that is done. Let's do a new one, if you don't mind, real quick. And that way it shows what the offer is now. Yeah, it's on the tablet. I'll hold it for a minute while y'all get that taken care of, please. Thank you.
Judge, I would ask that the court admonish,
I will when you get that done.
Okay, all right.
Yes, sir. I'll go through the whole thing. Good morning. Are you Perry Hurd Jr.?
All right.
Yes or no, please?
Yes.
Stand up. Thank you. And Mr. Hurd is charged with harassment of a public servant from November 24th of 2025. And what is the announcement?
Judge, I've met with Mr. Hurd, and I've also talked with Mr. Smith in regards to this matter. And evidently, there's some questions in regards to his criminal history that I need to speak with Mr. Hurd about. I mean, I was under the impression that there wasn't any additional criminal history that we were dealing with other than this, and then there is especially some out of county stuff.
Okay.
So I need to go over there with Mr. Hurd and check those judgments.
Okay. I know there's one listed in the indictment, but there's more than that.
Right.
Okay. All right. So I'm going to reset the case. That'll give Mr. Lewis some time to get all of that information regarding criminal history so that you know what your possible consequences are, what your options are, and we'll get an announcement at the next 5 days. You can go back to the court. Good morning. Are you Dominic Lee? Good. And you're Dominic Lee?
Yes, ma'am.
And Mr. Lee is charged with criminal mischief in cause number 25 DCCR 1784. And what is the announcement?
Judge, we've actually got a new offer from the state in regards to this matter. There is one other piece of discovery that I did receive that I do need to go and watch with my client.
Okay.
It is some video of the actual. Initially, we had still pictures. Now we have the actual video.
Okay.
So I'm going to go and look over that with him and go over that offer with him. And I think, we'll probably get it resolved by the
Sure.
next day.
All right, I will just reset a normal reset. Mr. Lewis will be out to see you soon with all that information, and then we'll get an announcement at the next court date.
All right.
All right, you go back with the bailiff.
From confusion to pressure to a decision that could change everything, this case didn't go the way he expected. In court, every word matters, and one wrong statement can cost you big. Now the real question is, was the judge being fair or too harsh? Let me know what you think, because this one is not so simple.